Hello, friends. I'm Naavi of Naavi.org, and today we will discuss one of the developments which has hit us in the last few days, particularly for the CitiBank customers. We had heard that sometime back the CitiBank actually decided to exit its consumer business from India, and Axis Bank had acquired its consumer business, which meant that more than 3 million customer accounts, which could be the current accounts, savings bank accounts, and even credit card accounts of Citibank would be bought over by the Axis Bank. We understand that a consideration of nearly 12,000 plus crores was negotiated for this particular deal. And this deal was negotiated by several internationally renowned consultancy firms, which included PwC, BCG, Credit Suisse, and Axis Capital itself. Additionally, there were support from the legal consultancy from Khaitan. So there were adequate, I can say, support of consultants. But what has happened is that last Wednesday, I think 9th or so, suddenly in particularly Bangalore, we saw that there was a crowd assembling in front of Citibank branches because they had received a message just then that their accounts have been closed. Some of the customers say that for a long time they had been receiving the notices from Citibank that their accounts should be transferred to some other bank. In the past, whenever mergers of banks were handled in India, like the recent merger of Corporation Bank and Andhra Bank with Union Bank and other cases, the transfer of old accounts to the new bank was very smooth in the sense that no action was required by the customers. Automatically, the same account number was working for 3 to 6 months, even after the mergers were actually completed. And the checkbooks of the old bank were honored by the new bank for some time until, of course, the new bank took over. They had changed the account number subsequently. They had changed the checkbook, but internet banking transfer was very smooth, and except for small hitches, which could be expected even in normal times, the shift or migration of customer accounts to the new bank was not anything to be worried about. But what has happened in the case of this Axis Bank Citibank deal is that it is not a full-fledged merger. So that I think Axis Bank could not get the full control of the data server of Citibank, or they did not negotiate for proper control. So perhaps it was left to Axis Bank to actually migrate account by account, where account holders had to close their Citibank account and then open a new account with Axis Bank. This was a very unprofessional way of handling the migration, to which we have to hold all the consultants responsible. So because of this, while a few alert customers did close the account and shifted to either Axis Bank or to a bank of their own preference, there were a number of customers who did not take any action, and suddenly they found that they received I think an SMS notice or an email notice saying that your accounts are no longer active. As a result, customers who had issued checks which were uncleared perhaps got stuck with a possibility of dishonoring of the checks. And there was also a possibility that any incoming credit, which was part of earlier standing instruction, or maybe even international transfers, they got stuck and went back. And if the customer had delivered any goods or anything, they would be now left to the mercy of the buyer to actually reinitiate the payment. So these were the issues which were created by the sudden discontinuance of the account by Citibank. Now, Citibank may justify that they had sent several notices and the customers did not act. And I would like to hold Axis Bank also very irresponsible, because they should have looked at this as an opportunity to get these 3 million accounts into their account. If that doesn't happen, then their 12,000 crore payment should be questioned by their shareholders on whether it was properly planned. Axis Bank should have ensured that all accounts are migrated to their accounts, unless there's some people who may dislike Axis Bank for various other reasons. So there was lack of effort on the part of Axis Bank to get the migration done, and lack of cooperation by Citibank in ensuring that the accounts are migrated before taking the drastic decision of sudden deactivation. See, banker-customer relationship is always considered to be a very sacred relationship which supports the business of the customer, and the bank should not consider this as an ordinary contract and do things at its own free will. So withdrawal of the customer relationship should be done very securely. Otherwise, the bank should be able to take liabilities on account of wrongful dishonor of checks and other consequences, including denial of service, which is an offense under Information Technology Act. Now, Citibank would be exposed to those risks. And of course, they will try to defend, saying that they had given adequate notice and other things. Now the question shifts to the role of Reserve Bank of India. What action did they take to ensure that this inconvenience is not caused to the customers? Now, Reserve Bank may say that this was not a merger initiative, it was just a business division transfer. But still, since it was related to the banking domain, I think Reserve Bank of India should have exercised their oversight on this merger or say acquisition. Perhaps there was a lacuna there also. We do not know the full details of this, and perhaps it will emerge in the next few days. But as a person who is looking at Information Technology Act and related issues, I consider that this is an opportunity for us to look at the concept of due diligence on merger and acquisitions. Now, in the data protection area, we know that law gives some special status to mergers and acquisitions. And in fact, there is a consent exemption provided in such situations, because the law wants not to disrupt the business. But at the same time, under Information Technology Act, there is a provision which says that it is incorrect to cause denial of access of any IT system. And in this particular case, the customers are being denied access to the system, which is actually an offense under Information Technology Act. It could also result in a Section 43 liability, under which a customer can claim compensation for the wrongful loss caused to him by approaching the adjudicator of the respective state. And police can prosecute Citibank for denying the access under Section 66 of Information Technology Act. And the defense which the Citibank will have to provide in that kind of a situation is the due diligence concept. Now, what is due diligence in this particular circumstance needs to be determined by experts in the area. I personally feel that apart from the usual sending of notices one time, second time, third time, or whatever is that, there should have been a newspaper advertisement, perhaps jointly in the name of Axis Bank and the CitiBank, alerting the customers that within the next week or so, a day will come and your accounts will get deactivated. See, normally in legal these things, we say that notice has to be given in two newspapers. One of it should be vernacular or something like that. And I think that kind of principle should have been followed even for this discontinuance of the accounts, irrespective of the contractual agreement between Axis Bank and CitiBank, which might have said that it is the responsibility of Axis Bank to give notice and take over or whatever is that. I think as a best practice, a good newspaper advertisement was in order. It was not done. Now, when you say email or SMS, now if banks normally say that we never send emails or something like that, so many customers would not act upon such emails, particularly when those emails are not digitally signed. Citibank does not send digitally signed emails. And until a couple of days back, Citibank was continuing to market their credit cards. And from the Citi card division, emails used to come to the cardholders. I am told that one of the customers even received checkbooks after this February 9th, when the accounts were deactivated, showing that the bank itself had not thought of deactivation on this particular day, at least a week or 10 days before that date. So it was a sudden decision, and it was taken in such a manner that the customers' difficulties were completely ignored. So in terms of due diligence, the notices could be found insufficient. What I feel is that the advisors, the financial advisors which were involved, they were only interested in some kind of negotiating the compensation, 12,135 crores or 10,000 crores or something like that. They were not interested in the impact of this business on the customers, which could provide a legal risk where there could be a public interest litigation and thousands of crores of compensation can be claimed by the customers. Had it been in USA, it would have been perhaps done. Here, of course, we don't know whether that will happen, but that is a legal risk which ought to have been factored into the consultancy proposal. And the bank should have, both the banks should have been advised on how to handle that situation. For example, the withdrawal of the banker-customer relationship should not be abrupt, and it has to be in a graded manner. Like, let us say, they could have, first of all, said that any new incoming credit would be disallowed after a particular time, which means that the balances in the account would run down. And then after a week or 10 days, they could have said that the withdrawals would be restricted to a particular value, not more than 25,000 rupees or something like that, so that small checks would not be affected. Larger checks would still be, could be returned. Even that kind of a notice should have at least 3 months' time, because normally a check would be declared stale after 3 months. So after giving a 3 months notice, the checks could have been deactivated, at least at higher value, and then give another 1 week, 10 days for the smaller value checks to be deactivated. And of course, all through this phase, cash withdrawals as well as deposits would have been prevented or barred. So some phased deactivation should have been thought of, rather than taking this decision to stop the accounts on a particular day. I feel that an experienced banking customer like Citibank should have thought about protecting the interest of even its outgoing customers, because they were once your customers. So there is no reason to think that once you have tried to exit the business, these past customers, you don't have any responsibility. It is a very bad reflection on the customer orientation of CitiBank. And for Axis Bank, I say it's a marketing failure, and they have not been able to win the goodwill of the customers. And most of these customers who have been troubled now would not shift to Axis Bank. Perhaps they would shift to other banks, because anyway, if you are closing the account and you are going to get a DD, and the customer can very well use that DD and then open an account in some other bank like a Canara Bank or a State Bank of India, or even ICICI Bank or HDFC Bank, and they need not necessarily go to Axis Bank. Whereas if Axis Bank had worked diligently, they could have automatically transferred this entire set of accounts to its kitty, and then people withdrawing from there and going to another bank would have been far less. I think it is therefore a big marketing failure on the part of Axis Bank. On the part of Reserve Bank, there is a failure of oversight. They did not give any public notice that this is coming up. They could have done that. They could have released an advertisement on their own to protect the interest of Indian banking customers of Citibank, because Citibank was one of the licensed banking institution in India, and Axis Bank also is one such licensed banking system. So there is failure of Reserve Bank of India. I also hold that the consultants like the Axis Capital, the Credit Suisse, PwC, BCG Consulting, and as well as Kaitan legal consultants, all of them have failed in their duty to look at the impact of this decision on the customers and take adequate action. It speaks very low of their say expertise. Sometime back, some politicians were telling that if the auditors are big firms, then it is safe for the investors. This case is another case which says that it is not a question of how big a consultant is, how dedicated is he to the particular consultancy assignment, and what is his level of understanding of the impact. I have earlier pointed out the Net4 India incident where the digital assets in the form of domain name customers was completely ignored by the consultants who worked on the insolvency petition, and also the national that is company tribunal. They were also ignorant, and they did not protect the interest of the domain name customers in that case. Similarly here, the regulators, the consultants, and the parties themselves have failed to protect the interest of the bank customers. I hope that this will give rise to development of a suitable due diligence plan for acquisitions and mergers, which should be used in future, so that this kind of a problem doesn't happen once again. Thank you, friends. If you have any comments, you can send it to me. I am trying to give this kind of discussions on this channel from time to time. So if you are interested, you should subscribe to this channel also. Thank you.